So good morning and thank you for joining the Burness Paul Junior Energy In-House Lawyers webinar series. Our webinar today is an overview of the National Security and Investment Act 2021. I'm Jennifer Ray, a director in Burness Paul's energy team, and I'm one of today's speakers, joined by my colleagues Emily and Robbie. Firstly, just a bit of housekeeping. Once you've joined, please ensure your mute button has been selected to limit background noise. Today's webinar won't be interactive, so please do contact any of our speakers if you have any questions. The webinar is being recorded, and if you have any queries on that, check out our privacy policy, which is on the Burness Paul website. So what are we going to cover in today's section? We're going to look at an introduction to the National Security and Investment Act, so NSIA, as we go through the slides. The NSIA annual report for 23-24, looking at trends within the sector. Energy as a sensitive sector under the NSIA. Practical implications for in-house counsel. When to make a notification, and some key takeaways for today's session. A bit of an introduction to the Act. It was passed in 2021 to ensure the UK government has scrutiny and blocking powers over certain categories of transaction in certain key sectors, which it had determined are of critical national importance. The NSIA requires that the acquiring person entity must give notice to the Secretary of State via the Investment Security Unit, ISU, before the acquirer, pursuant to a notifiable acquisition, gains control in circumstances described in the legislation. Transaction clearance is required in advance of the transaction taking place, i.e., clearance can be mandatory, and if clearance is not obtained when it should have been, then a transaction can be voided. Our criminal sanctions and fines may apply, which we'll touch on later in this webinar. I'll now pass you on to Robbie to talk you through how the regime works in more detail.
Thanks, Jen. So first to focus on the mandatory regime. The regime requires proposed acquirers of shares or voting rights which exceed trigger thresholds in companies and other entities undertaking specified activities in the UK in certain sensitive sectors of the economy to notify the transaction and obtain government approval before completing the transaction. The mandatory regime covers 17 key sensitive sectors and only applies to acquisition of shares or voting rights. To cover briefly what the 17 areas are, these are advanced materials, advanced robotics, artificial intelligence, civil nuclear, communications, computing hardware, critical suppliers to the government, cryptographic authentication, data infrastructure, defence, energy, military and dual use, quantum technologies, satellite and space technologies, suppliers to the emergency services, synthetic biology and transport. It is important to remember that it can apply to follow-on investments if said follow-on investment tips the holding over the notification threshold. Generally, there is no minimum turnover or size of transaction in terms of monetary value for mandatory notifications, but within the sector definitions, there are some thresholds which may trigger a mandatory notification. It is key to note that no matter how big or small, a transaction may be captured within the mandatory notification regime. A mandatory notification is required when a person gains over 25%, 50%, or at least 75% of shares or votes in a qualifying entity. The responsibility for making the notification is on the acquirer, and the notification is made via a government portal to the Investment Security Unit, ISU, which sits within the Cabinet Office. Once notified, the government screens the transaction and will either request more information, provide clearance, reject the transaction, or approve the transaction subject to various conditions. Now to move on to the voluntary regime. The NSIA provides a mechanism by which the parties can voluntarily trigger a notification to the Secretary of State in order to obtain a call-in decision in relation to the transaction in circumstances where there is no requirement to notify under the mandatory notification, but parties believe the acquisition could raise national security concerns. The voluntary regime sits alongside the mandatory regime, but it has a much wider scope. It is not linked to key sectors, but instead the Act refers to matters which could be detrimental to national security. The government has deliberately not defined what amounts to national security concerns, nor what factors must be considered when assessing national security risks. The government has given some guidance via Section 3 statements, but this guidance has been very limited. The voluntary regime applies to share sale transactions and asset purchase transactions, including the purchase of IT or land. As well as the defined share and voting right thresholds that apply to the mandatory regime, the government will also consider whether the acquisition will result in the acquirer obtaining a material influence over an entity, which could cover shareholdings as low as 10 to 15%, or material influence over an asset. So as you can see, basically, the voluntary regime is very broad. I will now pass on to Emily to discuss the powers that ISU has and the sanctions that may be applicable for non-compliance.
Thanks, Robbie. So the government has wide powers to call in a transaction where it considers that the deal gives rise or may give rise to a national security risk. In general, the call-in power can be exercised within 5 years of the acquisition completing or within 6 months of the government becoming aware of it. However, where the acquisition is subject to mandatory notification but has not been notified, there's no time limit on the call-in powers in those circumstances. The government's call-in power applies whether or not the transaction was notified. If the transaction is notified, the government are required to accept the notification. There's no period during which they must accept the notification, but in our experience, this usually takes anywhere between 2 to 5 working days. Once accepted, the government are required to exercise their call-in power within 30 working days from the date of acceptance. If the government calls in the transaction, it has 30 working days to conduct a detailed review. This period can be extended by a further 45 working days or more with the acquirer's consent. Sanctions also apply to retrospective notifications, which should be made if you believe that a transaction has already completed and should have been notified. There are 3 risk categories which the government will consider when exercising this power. The first being the target risk, which concerns whether the entity or asset being acquired could be used in a way that poses a risk to national security. The second relates to the level of control being acquired and whether that control could be used in a way that poses a risk to national security. And the third is whether the acquirer has characteristics that suggest a risk to national security. The sanctions for non-compliance with the regime are severe, including transactions being declared null and void, criminal sanctions up to 5 years imprisonment for individuals, and fines of up to 5% of worldwide turnover or £10 million, whichever is greater. I'll now move on to the NSA annual report. So the government produces an annual report on the operation of the Act, which provides an insight into its impact on certain areas of investment in the UK. The annual report published in September last year confirmed that 906 notifications were received during the review period, of which 753 were mandatory, 120 were voluntary, and 33 were retrospective. 41 call-in notices were issued, but no final notices were issued to block or unwind an acquisition. In terms of the impact on investment in the UK economy, there were call-in notices to 16 of the 17 sensitive sectors, with transport being the only sector to have no associated call-ins and the defence sector having the highest share. Acquirers associated with China were linked to 41% of call-in notices and 48% of final notifications. Most withdrawals and final orders were associated with acquirers from China, the UK, and the USA. Statistically, the government takes 28 working days to call in a mandatory notification following acceptance and 29 working days to call in a voluntary notification once accepted. The government identified 34 notices where acquisitions occurred without the necessary approval. No penalties were imposed during the review period, but businesses were asked to take corrective steps to ensure future compliance. Further, no penalties or criminal prosecutions were concluded in the review period. I'll now pass back to Robbie and Jen to talk about energy as a sector.
Thanks, Emily. So, as I previously mentioned, energy is one of the key sectors where notification is required. So we thought it would be helpful to discuss how energy is viewed under the NSIA. The government believes that there are certain areas within the sector that are sufficiently sensitive and that should be included in the mandatory notification requirement. The scope of the energy regulations covers clean energy transactions, such as those relating to electricity. The NSIA states that electricity activity refers to the onshore and offshore generation, storage, aggregation, transmission or distribution of electricity across Great Britain, but not Northern Ireland. It contributes either directly or indirectly to the supply of power to homes and businesses. Any project participating in the transmission of electricity and requires a transmission licence can trigger an NSIA notification or can be eligible for an exemption. Large generation projects can also be notifiable and has potential to be far-reaching, with projects over 1 gigawatt becoming notifiable. Small single acquisitions of operational assets can be brought into the mandatory notification regime, depending on the generating assets of the acquirer. This would be triggered, for example, where an acquirer, its parent undertakings and its subsidiaries together hold a portfolio amounting to 950 megawatts of generating assets, regardless of individual asset size, and the acquirer intends to buy a 60 megawatt project, therefore surpassing the 1 gigawatt threshold. Jen will now discuss what other energy areas the NSIA covers.
Thanks, Robbie. So the energy definition of the regulations also covers upstream oil and gas, downstream gas, and downstream oil. Each subsection has its own requirements, and it depends on whether certain thresholds or tests are met as to whether notification is required for this part of the NSIA. It should be flagged that the NSIA is drafted relatively widely, and often concepts are not defined, which can lead to confusion, such as for upstream oil and gas. Part of the test is whether the target owns or operates a relevant facility. What an operator is as a relevant facility is not defined, so it's not clear what the government means in this context, and it's not linked to any other definitions or legislation which those in the sector may be familiar with. Whilst the focus of this webinar is the definition of energy, this is a reminder not to forget about other sectors which could be relevant to your energy business. For example, does the target business have a contract with the Ministry of Defence? This could mean that a notification is required pursuant to the key area of defence, which Robbie mentioned earlier. Other matters which we've seen result in a notification for an energy business, but not using the energy definition, are advanced materials. In this scenario, the target manufactured products using certain materials which the government wishes to know about in the interests of national security. The use of AI is also covered in certain scenarios, depending on what AI is built into the target's products. Civil nuclear also has its own section. Essentially, we'd encourage the legislation to be reviewed for each transaction by someone in the buy team or indeed the seller team that understands what is being acquired and whether it might fit into one of the sections that could necessitate a notification. So, what are some of the practical implications for in-house counsel if the NSIA is relevant? Firstly, risk management and appetite. As we touched on earlier, the consequences of not making notification when one is required can be severe. Bearing that in mind, sometimes if there is an ambiguity as to whether a notification is required, an acquirer would prefer to make a notification to provide deal certainty that clearance has been provided, particularly due to the call-in powers that Emily touched on earlier, which can cause delay or cause a lot of information to be provided after a transaction has occurred if clearance should have been applied for. Also, landing considerations. If a notification is required due to what the target business does and the shares in that transaction are currently held by a lender due to Scots law security arrangements, not only is a notification required for the actual transaction, but a notification or inclusion in the application in relation to the security release should also be included in the application, as the transfer of shares held in security is also an acquisition for the purposes of the legislation. Please note that this is in relation to Scots law secured shares which have been pledged, i.e. put in the name of the relevant lender, and not English law secured shares or shares which are secured utilising the new pledge regime brought in by the new movable transaction legislation. Intergroup reorganisations are also covered. So far in this webinar, we've talked about buyers and sellers, but the legislation does not just apply to third-party transactions. It should also be considered for intergroup reorganisations and indeed joint ventures, as whether one of the 17 sectors applies or if there is a general national security concern. A mandatory notification could still be required in the case of a share transfer, or a voluntary notification could be required in the case of an asset transfer for both a joint venture or intergroup reorganisation, for example. We have seen a notification be required for an intergroup reorganisation where the subsidiary in the target chain held licence interests and the necessary throughput test for the upstream oil and gas definition was met. Also, executive team and board awareness. It's important that the NSIA is on the radar for the decision makers for the transaction due to the consequences mentioned. Also, if a notification is required, an authorised representative of the acquirer must sign off on the notification as part of the submission to the ISU to confirm the details provided in the application are accurate, which may require internal approvals. It's also a reminder not to forget about similar cross-border transactions and foreign direct investment regimes in other jurisdictions. As mentioned, it does not matter that the acquirer is not a UK entity. It matters whether there is a UK link for the purposes of the NSIA. However, the NSIA is not the only regime of this nature where there are applicable regimes in other countries such as the USA, Norway, Australia, but several other countries may be relevant to the jurisdiction you operate in. So it's important to bear in mind if there are subsidiaries or targets in other jurisdiction that local advice may be required for similar regimes. As Emily touched on earlier, there may be an impact on deal timelines. Once a notification is submitted, the government has a time period to consider whether to accept the notification. There is no set period for this, and in our experience, this usually takes anywhere between 2 to 5 working days for the government to accept the initial application. It is also possible for a notification to be refused if certain information is missing or further questions to be submitted by the ISU before acceptance is granted. Once a notification or application is accepted, the government has 30 working days rather than calendar days from the date of accepting the notification to either clear the acquisition or call it in for a national security assessment, as Emily mentioned earlier. If a call-in notice is issued, the assessment period is initially 30 working days, which can be extended by a further 45 working days or more with the acquirer's consent. So it is important to build sufficient time for a notification to be made into any deal or transaction timeline. Statistically, most notifications are giving clearance within the 30 working days of being accepted, but it is not always the case. And we usually do find that the unit takes near enough the full 30 working days, even if matters are straightforward to issue a clearance. Just as a reminder, The acquisition is void if you complete a notifiable acquisition, which is the subject of a mandatory notification, without notifying and gaining approval from the government. However, you will be able to retrospectively validate by applying online. This is still subject to the same review timelines and consequences, and the ISU can impose conditions and require the inquirer to give certain confirmations regarding the completed transaction, as Emily mentioned when reviewing the NSIE report from 23-24. Emily will now consider some other practical implications.
Thanks, Jen. Some other practical points to consider include early stage engagement. Given the timescales for the government to provide clearance, as we've discussed, it's important for there to be early engagement between the parties to determine the Act's relevance. In practice, we often see notifications being made in advance of the share purchase agreement being prepared, but we also see NSIE approval as a condition to completion in a split signing and completion transaction. Although this is a buyer-led process, as they are responsible for submitting any application, the sell side play a key role in supplying accurate information to the buyer, as they will know their business best. Care should be taken when providing information, as penalties may be imposed on the buyer if the information in a notification is incorrect or misleading. Sellers should also be aware that there are no financial thresholds when determining the relevancy of the Act, so all of the business's activities are relevant even if they do not materially contribute to its revenue. The buyer should ask specific due diligence queries to determine the relevancy of the Act. The sell side may also seek information on the ultimate owner and affiliates of a potential buyer or its investors. Sellers should anticipate the questions buyers will likely ask and collate the required information in advance of the due diligence process commencing. We also see NSIE approval be included as a condition precedent. If consent to a transaction is needed, government clearance should be included as a condition precedent to completion with the appropriate undertakings from sellers to cooperate with the consent process, including providing all necessary documentation and information. I'll now move on to the government notification diagram. So the government has produced the flowchart, which is on screen, which is designed to provide an initial steer on notification requirements, although this is very basic and there are a number of additional factors that need to be taken into account. When determining whether or not a notification is required, you should consider whether the entity or asset being acquired has sufficient connection to the UK to fall within the scope of the Act. If there's not sufficient connection, then no notification is required. If the transaction relates to an asset sale as opposed to a share sale, notification is not required, but you may submit a voluntary notification. Similarly, if the acquisition does not fall within the scope of the mandatory regime, you do not need to notify, but you can submit a voluntary notification. If the target has sufficient connection to the UK to fall within the scope of the Act, is a share sale rather than an asset sale, and falls within the scope of the mandatory regime, the buyer must notify the government of the transaction and consent must be obtained prior to completion. I'll now pass back to Robbie to discuss the key takeaways from today's session.
Thanks, Emily. So to summarise, here are the key takeaways relating to the NSIE. Certain transactions in the energy sector are subject to mandatory notification, and it is a criminal offence backed by significant sanctions to complete a relevant transaction without clearance. This applies to many transactions involving entities active in the nuclear sector, upstream petroleum facilities, electricity and gas transmission, distribution and interconnectors, generation and aggregation, gas processing facilities and LNG terminals, and the supply of petroleum-based road, aviation, or heating fuels. In most cases, an acquisition of more than 25% of the shares or voting rights will be required to trigger a mandatory notification. But that will not always be the case, and certain acquisitions of lower stakes can also be called in for review, if they are not subject to mandatory notification. Although asset deals are not subject to mandatory notification, they may also be called in for review. The obligation to obtain clearance applies to transactions signed before 4th of January 2022, but which close after that date. Further, transactions that closed after 12th November 2020 may be called in for retrospective review, often for up to 5 years after they occur, or 4th of January 2022 if later. The regime applies to the UK as well as foreign investors and may apply to transactions which have limited connection to the UK, albeit a mandatory notification is unlikely to be required in such cases. The review timetable may be relatively lengthy, particularly for deals which are called in for a detailed national security assessment. It's also key to note that intragroup transactions and joint ventures are not exempt from the NSIA. And due to the potential repercussions, it is imperative that the NSIA is taken into account at an early stage of planning transactions in the energy sector. So this concludes our overview of the NSIA. As discussed, our session today will be recorded and you will shortly receive an email with a link to the recording of this session. In that email, you will also find a link to register to further sessions and learn more about the programme. The upcoming 3 webinars in the series are highlighted on the screen now. Our next webinar is taking place in a month's time on the 25th of June, where some of our colleagues will be discussing joint ventures and corporate structures in the renewable energy sector. In the meantime, if you'd like to hear more about any of the topics covered today, or if you have any specific queries for us, please do reach out to one of the team and we'd be delighted to hear from you. So thanks very much for your time today, and we'll hopefully see you at future sessions.